Look, Waqf is a parallel system of government that's been running in this country. And if we are to stop India from becoming an Islamic Republic of India, we have to not just amend the Waqf Act, we have to abrogate it. Let me give you a little bit of background about what Waqf actually is. It is the third largest landowner in India after defense and the railways. The third largest, with much of its land holding rather amusingly pre-independence, an endowment of the insidious give and take between the British and the Muslims they desired to pacify. Indeed, many of the Waqf land holdings go as far back as 1857. 77% of Delhi is supposed to be on Waqf land, including the Delhi High Court. Central Vista, which has recently been renovated and on whose hallowed turf new government buildings will shimmer and glisten, is on Waqf land. CGO Complex and Jawaharlal Nehru Stadium are on Waqf land. Only three things are certain in an Indian's life: death, taxes, and that knowingly or unknowingly he ends up walking every day on Waqf land. Over time, many of these Waqf properties were taken over by the government, but then inexplicably, or perhaps not, one of the last decisions of the outgoing UPA government in 2014 was to gift 123 prime central Delhi properties to Waqf and withdraw its claim on them. These prime real estate properties are from the time of our independence and were endowed to the government by the departing British. Their status remained unchanged for 70 years until 5th March 2014, when the departing Congress decided to endow them to the Waqf. Even the Delhi High Court judges have opined that Waqf land is Allah's and Allah's alone, and that the government cannot be the owner of this land. It is not just government buildings that the Waqf claims to be its property. Mukesh Ambani's house is on Waqf land. The Waqf Board lays claim to 354,913 estates and 866,035 properties comprising 802,000 acres of Indian land, with Uttar Pradesh having the highest share of 213,833 Sunni Waqf Board properties and 15,386 Shia Waqf Board properties. This data is from the Waqf Management System of India, whose motto, if you visit their website, is once Waqf, always Waqf. One will, if they were to go deeper, find that this grandiose motto is not the idea of or thinking of the Waqf Board or any of its members. It is in fact the verbatim exclamation of the Supreme Court in its 1998 judgment, case number 4372 SCR 398. In the name of the Honorable Judge who said this iconic line, Justice Dr. Anand. Look, Waqf essentially means that any donated property belongs to Allah in perpetuity. Waqf decides any property adjudged by Muslim law as pious, religious or charitable, and therefore fit to be labelled as Waqf. In other words, Waqf is inalienable and irrevocable. If you think this is a figment of my fertile imagination, let me quote directly from a Waqf Board document. Quote, Waqf is a voluntary, permanent and irrevocable dedication of a portion of one's wealth in cash or kind to Allah. Once a Waqf, it never gets gifted, inherited or sold. It belongs to Allah and the corpus of the Waqf always remains intact. The fruits of the Waqf may be utilized for any Sharia compliant purpose, unquote. The Waqf boards are, in case you were wondering, headed and constituted by Muslims. If that was not discriminatory enough, let me run you through some sections of the Waqf Act 1995 to make it abundantly clear how draconian this act is. Section 4 bestows on the Waqf Survey Commissioner the authority and power like that of a civil court. Section 8 says the state has to pay for the Waqf survey. The state. This is in direct violation of Article 27 of our Constitution that says no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination, unquote. Besides, the entire cost of the surveying is to be borne by the state. So in a sense, a Hindu's property once declared as Waqf property, wholly arbitrarily, will be surveyed by Waqf, and the cost incurred on this count will be not by the Waqf itself. And people say, we are living in a fascist Hindu Rashtra. Section 40, I'm not done yet. Section 40 gives the Waqf power to decide if your land is Waqf or not. In fact, if your property is laid claim to by Waqf, it is your responsibility to disprove its claim. And till such time you disprove it, it is Waqf land. Quote, decision if a property is Waqf property. 1. The board may itself collect information regarding any property which it has reason to believe to be Waqf property. And if any question arises whether a particular property is Waqf property or not, or whether a Waqf is a Sunni Waqf or a Shia Waqf, it may, after making such inquiry as it may deem fit, decide the question. 2. The decision of the board on a question under subsection 1 shall, unless revoked or modified by the tribunal, be final. 3. Where the board has any reason to believe that any property of any trust or society registered in pursuance of the Indian Trust Act 1882 or under the Societies Registration Act 1860 or under any other act is Waqf property, the board may, notwithstanding any contained in such act, hold an inquiry in regard to such property, and if after such inquiry the board is satisfied that such property is Waqf property, call upon the trust or society, as the case may be, either to register such property under this act as Waqf property, or show cause why such property should not be so registered, provided that in all such cases notice of the action proposed to be taken under this subsection shall be given to the authority by whom the trust or society had been registered. आपको नहीं देंगे, उसको देंगे जिसने आपको register किया था, आपको पता भी नहीं चलेगा. Number 4. The board shall, after duly considering such cause as may be shown in pursuance of notice issued under subsection 3, pass such orders as it may think fit, and the orders so made by the board shall be final, unless it is revoked or modified by tribunal, unquote. Section 54. What is section 54? It gives the Waqf the power to declare you an encroacher. Quote, removal of encroachment from Waqf property. 1. Whenever the chief executive officer considers whether on receiving any complaint or on his own motion that there has been an encroachment on any land, building, space or other property which is Waqf property and which has been registered as such under this act, he shall cause to be served upon the encroacher a notice specifying the particulars of the encroachment and calling upon him to show cause before a date to be specified in such notice as to why an order requiring him to remove the encroachment before the date so specified should not be made, and shall also send a copy of such notice to the concerned mutawali. 2. The notice referred to in subsection 1 shall be served in such manner as may be prescribed. 3. If after consideration and considering the objections received during the period specified in the notice and after conducting an inquiry in such manner as may be prescribed, the chief executive officer is satisfied that the property in question is Waqf property and that there has been an encroachment of any such Waqf property, he may make an application to the tribunal for grant of order of eviction for removing such encroachment and deliver possession of the land, building, space or other property encroached upon by the mutawali to the Waqf. 4. The tribunal, upon receipt of such application from the CEO, for reasons to be recorded therein, make an order of eviction directing that the Waqf property shall be vacated by all persons who may be in occupation thereof, of any part thereof, and cause a copy of the order to be affixed on the outer door or some other conspicuous part of the Waqf property. मतलब वो Waqf property हो गई. Provided that the tribunal may, before making an order of eviction, give an opportunity of being heard to the person against whom the application or eviction has been made by the CEO. 5. If any person refuses or fails to comply with the order of eviction within 45 days from the date of eviction of the order under subsection 2, the chief executive officer or any other person duly authorized by him in this behalf may evict that person from and take possession of the Waqf property, unquote. So let me get this straight. the Waqf decides in its wisdom that a property is Waqf property. It then serves a notice to the encroacher. Subsequently, it takes the matter to the Waqf tribunal, and the tribunal decides on the nature of the said property and orders eviction. The terror continues paragraph after paragraph, sections after section. Section 85 states, quote, "No suit or other legal proceeding shall lie in any civil court in respect of any dispute, question or other matter relating to any Waqf property or other matter which is required by or under this act to be determined by a tribunal," unquote. In fact, even the Supreme Court declared that in 2019 that a civil court of India has no jurisdiction in the matter of a suit pertaining to Waqf property. Let me remind you of the ground reality. Waqf tribunal decision can only be overturned by a long and financially draining legal process. The Waqf knows this, of course they do. In a country where 5 crore cases are pending, harassment through legal procedure that stems from the inner offices of an all-appeasing government, executive and judiciary, is a sword that is sharper and more potent than Khalid's. How, one may then ask, has the Waqf Act 1995, that is patently unfit to be applied to leave alone a mental asylum, has been applied to a nation of 1.4 billion people, assuming the two are not one and the same? Remember, there is nothing in the act that safeguards the religious properties of Hindus being appropriated by the Waqf. This itself violates not only the principles of natural justice, but also multiple articles of our constitution, beginning from Article 14, 15 and 25. BJP's enfant terrible Ashwini Kumar Upadhyay recently filed a petition in the Supreme Court challenging the validity of the Waqf Act. His plea was that the Waqf Board has Muslim MPs, MLAs, legislators, civil servants, lawyers and scholars as its members, and they are remunerated by the taxpayer, even though the state does not collect money from mosques. How is this secularism? The Supreme Court refused to entertain the plea and threw it out. The judge called the petition abstract. That judge is now and will remain for the next many years the Chief Justice of India. The mayhem continues. Here is section 28 that outlines the power of the district magistrate, additional district magistrate and subdivisional magistrate to implement the directions of the Waqf Board court. Subject to provisions of this act and the rules made thereunder, the district magistrate, or in his absence an additional district magistrate or subdivisional magistrate of a district in the state, shall be responsible for implementation of the decision of the board, which may be conveyed through the chief executive officer, and the board may, wherever it considers necessary, seek directions from the tribunal for the implementation of its decisions, unquote. Then there is section 107. Now in law, there is something called the statute of limitation, that is, the time period for acting on a dispute or filing of a suit is set by law. And this law is enacted through the Limitation Act of 1963. But wait, section 107 states, Act 36 of 1963 will not apply for recovery of Waqf properties. Nothing contained in the Limitation Act 1963 shall apply to any suit for possession of immovable property comprised in any Waqf or for possession of any interest in such property, unquote. What this means is that the Waqf can lay claim to and recover any property it wishes to without having to worry about passage of time. Kamal. Section 101, it says the survey commissioner, members of the board, every officer, every auditor of the board and every other person appointed to discharge any duties imposed on him by this act shall be deemed to be public servant as is understood by the Indian Penal Code. You know what that means? You know what happens when you touch a public servant, literally or metaphorically? मतलब अब मौलवी साहब भी public servant हैं. The Waqf, as you would have realized by now, is a parallel government, as I had said, wholly sanctioned by our own government. It has, through its overarching board, its own legislature, through its surveyors and estate and compliance officers, its own executive, and through its tribunal, its own judiciary. And through this act, through this application, a message is sent to every citizen of this country. We are a special people. And that message is all pervasive and uncompromising. It is this message that allows Muslims, even rational, logical and educated Muslims, to claim that the Gyan Vyapi mosque built atop the grand Kashi Vishwanath temple is on Waqf land. So, was the grand Kashi Vishwanath temple demolished by Aurangzeb and as confirmed through his own certified biography, Masir-e Alangiri, also on Waqf land? It is this message that allows Muslims to claim that the 1500-year-old iconic Mandyavali Chandrasekhara Swami temple in Tamil Nadu is on Waqf land. I ask you, how can a 1500-year-old Hindu temple be adjudged by Waqf to be on Islamic land when Islam is only 1300 years old? Kaise? Koi bata de mujhe. The more you read on Waqf, the more you realize that bulk of its muscle is flexed not only through the Draconian Waqf Act, but also through a letter that the former Prime Minister Indira Gandhi wrote during the emergency, ordering all states to strictly obey her diktats. If the Waqf properties, she wrote, have gone into adverse possession of state government departments, the Waqf Board could well start legal proceedings against the concerned departments. And where costly buildings have been put up by the state on Waqf land and their vacation is not feasible, the state government may enter into permanent leases with the Waqf boards, for after paying the boards, the bulk of the market value is premium. She further wrote that Waqf boards have sent governments lists of Waqf properties in the possession of the government departments. She urged to see that these are dealt with as suggested above. A periodic review should be undertaken and a monthly report to be sent to her. Waqf, as ordained by the committee and as agreed to by the centre, should be treated differently from individual landlords and therefore exempt from rent control acts. The Waqf only asked the Congress to bend. The Congress decided to crawl. In fact, during the dying days of the UPA, the Waqf Properties Eviction of Unauthorized Occupants Bill 2014 was tabled in the Rajya Sabha, giving overarching and draconian powers to the Waqf eviction officer to demolish whatever it considered was an encroachment of the Waqf property. Though this tabled bill, through not only was every other order made by the Waqf estate officer to be considered final, it could also not be called into question in any original suit or application, and no injunction could be granted by any court against it. But things did not just stop at injunction. The bill barred any Indian court to have jurisdiction to entertain any suit containing or concerning the eviction of any person from any Waqf property or demolition of any structure or fixture from any Waqf property. इतनी बार any कह दिया मेरा तो दिमाग पक गया है. Luckily for us, encroachers of Allah's land, the hard Congress went away in 2014 and was replaced by the soft Congress. Appeasement continues, if not through this draconian bill, at least in the interim through the 1995 Act. The Waqf Act 1995 is blatantly communal, discriminatory, unconstitutional, and draconian is not in contention, but only must read its clauses and sections to realize what a rotten hand Hindus have been dealt with through this act. What adds to the absurdity is the fact that this is now a perpetual motion machine, gobbling up land, property and government largesse with speed and stealth with every passing day, insatiable in its appetite, as though out to prove Dr. Ambedkar and his profound prophecy of Muslims under divine obligation to convert Darul Harb to Darul Islam. It is no longer an arcane endowment that is centuries old. It is an ever-growing mutant, having perfectly adapted to the appeasing and virtue-signaling state. Hindus who during the partition fled what is now Pakistan and came to India, their property was promptly confiscated and either distributed to the Muslim citizenry or taken up by the government of Pakistan. Not so the case with the Muslims who from India went over to Pakistan. Their property was handed over to Waqf. As a result, the Hindu must now beg for Waqf land to celebrate their festival, to live on Waqf land, as is what happened recently in Karnataka. However, governments, both the center and states, have usurped hundreds of thousands of acres of temple land and are responsible for more than 100,000 temples losing lakhs of crores in rental income. There is no such act for Hindus. There is no such act for Sikhs. There is no such act for Christians. There is no such act even for Muslims in Muslim majority countries like Turkey, Sudan and Egypt. As I say, welcome to the Islamic Republic of India. This is not our future. This is now our present. Thank you.